Today we're going to discuss ethics within the pharmaceutical industry. The people responsible for today's presentation are Stephanie Crawford, Krista Gillespie, and Jeremy Schreiber. Together, we all looked into the world of pharmaceuticals and discovered what led to the establishment of this pharmaceutical industry, what a typical code of ethics looks like within a pharmaceutical company, and we will look at 3 cases that deal with the aspect of employment law and look at what ethical decisions could have been made to steer away from these occurrences from happening, and just recapping on any issues that we've learned looking at this ever-changing industry. We are now in the year 2011. Looking back over the years, we can look at how things change and become more efficient. Where someone might consider starting their car with an application that they have on their phone, or pull previously purchased airline tickets up on their phone for security checkpoints. Whatever the case, modern technology is responsible for making life more efficient, streamlining processes, and reducing the overall workload. So many things can be done at once today. Technology is obviously not the only aspect of our lives to change and become more modern. The same can be said for the ability of the pharmaceutical companies to provide more efficient, streamlined, and effective products to make life easier or less painful. So many of us have found ourselves with having a headache or a cold or a stomach ache and reaching for the medicine that makes us feel better. It has become a part of our lives. Parallels, therefore, can be drawn between the industry sectors in order to facilitate the understanding between something we are familiar with, which is like technology, to something we're not necessarily familiar with, which is pharmaceuticals. So, what was responsible for the establishment of the pharmaceutical industry? The pharmaceutical industry established itself as part of key discoveries in 1922 and 1928, and since those dates the industry has been pioneering significant numbers of medicines to show the effects of how even the most deadly diseases can be cured. The establishment of this growing industry came after the discovery of insulin, which was the primary discovery, and then penicillin, which was the secondary discovery. The primary insulin was discovered at the University of Toronto in Canada in 1922 by Dr. Frederick Banting. The secondary penicillin was discovered by Sir Alexander Fleming at St. Mary's Hospital in London in the year of 1928. From the time of these 2 discoveries, the pharmaceutical industry has provided cures for countless diseases and continues to fight in the forefront of preventing types of cancers or HIV or other things. By interpreting the information about primary and secondary discoveries coming from Canada and England, one would know that the United States is not the sole powerful nation that would be assumed as in other industry sectors. So, what does all of this mean? With any key discoveries comes a windfall. A windfall as in a piece of unexpected good fortune, typically one that is receiving a large amount of money. In order to quantify the size of the industry, the top 20 pharmaceutical industries generated roughly about $235 billion in the year of 2010. Some of the top industries like Pfizer, Johnson & Johnson, which is also referred to as the company J&J, as well as Novartis, lead the way. In order to generate this type of revenue, these 20 pharmaceutical companies employ nearly 1.1 million employees. In order to continue to generate these high revenues, companies have to be ever-changing and be on the cutting edge. This means once products are produced, the newer products must be in their product pipeline. For example, these 20 pharmaceutical companies had 17,384 products as of December the 31st of 2010 in their developmental phase, meaning they were awaiting regulatory approval. The availability of such references prove that this industry is far too vast to track specific alternative methods to dispute resolution stemming from unethical management practices. So given record revenues and profits combined with complicated experimentation of medicines brings the need for remedies when faced with issues related to law, ethics, and or dispute resolution. In the Bible, in the book of 1 Timothy chapter 6 verse 10, it states, "For the love of money is the root of all evil, which while some coveted after, they have erred from the faith, and pierced themselves through with many sorrows." Interpreting that quote lends to the thought many people bring forth lawsuits because pharmaceutical companies have more than enough money to give. The focus of this vast industry will shift to Title VII of the Civil Rights Act of 1964, especially relating to employment law. Title VII relates to discrimination against any individual based on race, color, religion, sex, and national origin. The Act also covers areas of employment where discrimination may or may not occur. Since no two issues are identical, the Supreme Court, the District Courts, and the Appeals Court are extremely busy hearing cases related to discrimination. Our goal here is to outline specific cases specific to the subjective section of employment law, and to bring attention to the potential ability to facilitate alternative dispute resolutions to employment practices in the pharmaceutical industry. In recent news, the pharmaceutical company Novartis was sued by 12 female sales representatives for gender discrimination. Bayer Corporation and Bayer Health Pharmaceuticals were hit with a $1 million fine class action suit by female workers claiming gender discrimination in hostile work environments. With these growing trends, a company must show its commitment and dedication to employees, consumers, and society as a whole by having a code of ethics. A code of ethics is defined as a set of written guidelines issued by an organization to its workers and management, and to help them conduct their actions in accordance with its primary values and ethical standards. Looking at the world's largest pharmaceutical company, Pfizer, we can uncover what a typical code of ethics look like in this industry. Pfizer's code of ethics is called the Blue Book, and the Blue Book states how Pfizer takes pride in being compliant with Title VII of the Civil Rights Act by being an equal opportunity employer. Their policy states that it provides equal employment opportunities and treats applicants and employees without regard to personal characteristics such as race, color, religion, sex, orientation, age, gender identity, or even gender expression, marital status, disability, veteran status, or other characteristics applicable by law. These laws are a part of what is called natural law. Natural law is defined as a rule or body of rules of conduct inherent in human nature and essential to binding upon human society. Pfizer's Code of Ethics states that its goal is to maintain an honorable reputation by performing integrity when conducting business, and to act ethical and legal by making the right choice and making the right choices in business each and every day. The pharmaceutical industry has been coined with having the world's worst record of law-breaking industries than any other industry listed, by falsifying clinical studies, having off-label marketing, which means when sales representatives talk to the doctors and they tell them their drug will cure an actual disease that it hasn't been tested for. Price fixing and science fraud are just a couple of examples. When companies choose to commit one of these crimes, the company can lose a great deal of business. Pfizer was sued for an off-label marketing issue and was fined $2.3 billion, which is the largest fine ever imposed in the U.S. history. So acting ethical is very important in any industry. The leaders of this industry have to have and behave in ethical ways and to set examples for their employees, and employees must follow the code of ethics to help a company be successful. So next we're going to look at some cases where employees and managers choose to not follow the code of ethics. In the first case of Kirkpatrick versus Pfizer, we look at the issue of age discrimination in employment law. Karen Kirkpatrick was an employee at Pfizer. She had claimed that her new manager had made comments about her retiring and called her so-called old school on many different instances. She claimed the manager treated her differently than younger representatives and made her work harder. Her manager was approached about Kirkpatrick's work ethic, where stemming evidence had been shown that Kirkpatrick was not completing her work in a manner that was expected of every employee. Because of this investigation done by the Human Resources Department, Kirkpatrick was terminated as an employee at Pfizer. So she decided to sue Pfizer for age discrimination claims, stating she was discharged because of her age. The district court, as well as the Court of Appeals, ruled in favor of Pfizer, stating Kirkpatrick failed to show sufficient evidence from which a jury could conclude her age played a role in her termination. So what could have been done differently in this situation? To handle this issue, there are alternative measures that could have been taken to keep Pfizer out of court. Kirkpatrick's manager could have confronted her about the moment he learned about her working situation with respect. Respect is a key word managers should always do when confronting employees on issues. Managers need to be careful in their choice of words that they use with their employees. The words such as old school do not show much respect. And also, employees need to be monitored based on their performance regularly. When there's a problem with an employee, that employer needs to look at that employee and base their performance on when they actually talk to them and what they have over time. If performance has not improved and has been documented, then employees must be terminated. The regional manager here did do something right in this situation. He had proof, which is requesting the human resources to do a thorough search, which gave Pfizer the information needed to handle the case. In the second case, looking at the Tucker versus Merck & Company, Mrs. Tucker was an employee at Merck and decided to go work for another company called Bristol Myers Squibb. After a few years of working for Bristol Myers Squibb, Mrs. Tucker decided to go work back for Merck. The issue with this case began when Mrs. Tucker began to attend functions with Merck while still working for BMS. She was working and receiving 2 paychecks from 2 different companies at the same time. When Merck discovered these findings, Mrs. Tucker was terminated. And Mr. Tucker, which was Mrs. Tucker's husband, was also employed by Merck and was approached with questions of whether or not he was aware of his wife's actions. He denied acknowledgement of these actions, and therefore he and Mrs. Tucker decided, based on all these findings, to sue Merck for counts of defamation and invasion of privacy. The courts ruled in favor of Merck, finding sufficient evidence to prove Mrs. Tucker had indeed worked for 2 companies. So what could have been done differently in this situation? The problem first was how unethical Mrs. Tucker's actions were. Mrs. Tucker was working in a management role, so in this case she would have not been setting a good example for her employees. She should have been honest from the beginning about still being employed by BMS. If she would have been honest and not accepted payments from one company while working for another, the outcome could have been different. But in the end, it's better for Merck to let Mr. and Mrs. Tucker go and replace them with more ethical employees. The last case we'll look at today is the case of Cornell versus Pfizer, C&G Incorporated. This was actually based out of Canada. Mrs. Cornell was an employee at Pfizer, and she was placed on a probationary period during her employment. She claimed that on a number of occasions she requested equal pay as one of her male co-workers, to whom she viewed had the same job responsibilities as her. This case had to deal with the Employment Standards Act of 1974. Mrs. Cornell was later terminated and sued Pfizer for violating this act. This act basically states that all employees in the same type of job should have equal pay. No employer may differentiate between male and female employees. The court ruled based on the Addis versus Grantham Company as precedent, paraphrasing, damages for dismissal cannot include compensation for the dismissal, feelings as a result, or for the loss they may suffer to find new employment. So what could have been done differently here? 1. Make sure employees who are working the same job have the same tenure get equal treatment and equal pay. Managers need to make sure there are clear lines of communication. Employees need to feel like they are able to come to their managers and have open communication and an understanding between employee and manager. The good move in this case was the judge, making the right choice based on the precedent and disgruntled employee.